Now we move to Article 26. Article 26 guarantees religious denominations rights in regard to practicing their religion, the establishment and maintenance of institutions for religious and charitable purposes, acquiring property for religious purposes, as well as the administration of such property.
Let us now understand what constitutes a religious denomination. The Supreme Court held that a denomination must have the following characteristics.
A collective of individuals who adhere to a system of beliefs or doctrines and is conducive to their spiritual well-being. This is what is known as common faith. B. The collective of individuals need to form a common organization for their practice of their common faith. And C. The organization should be designated with a name. Applying this test, the Chistiya Sufis were held to be a religious denomination. Similarly, the Ananda Margis have been held to be a religious denomination, while followers of Sri Aurobindo have been held not to constitute a religious denomination as his teaching represented a philosophy and not a religion. Article 26 by itself does not create any right in property or any right to manage property in favor of any denomination if it otherwise did not possess this right. It merely safeguards and guarantees the continuance of any such right which such denomination already had. For instance, Article 26 does not entitle a denomination to claim the rights under Article 26 after the right is lost or surrendered or has been divested from a religious denomination. Every religious denomination has a right to establish and maintain institutions for religious and charitable purposes under Article 26A. The words establish and administer must be read conjunctively, and therefore, where an institution has been established by a religious denomination, it can claim the right to maintain the same as well. Clause B confers on a religious denomination or a section of it the right to manage its own affairs in matters of religion. The right is essentially an extension of the right to practice one's religion under Article 25. The word religion has the same meaning in Article 26 Clause B, and hence what is protected are the essential religious practices of a religion. Additionally, every religious denomination has the right to own, acquire, and administer property. Note that this right only guarantees that a religious denomination can own and acquire property like any other person. Such property can be acquired by the state, as is the case with any other property, following process of law. However, such acquisition must not be of a nature as to destroy a denomination or a religious institution.
Finally, under Clause D of Article 26, the state must leave the right of administration of property to the religious denomination itself.
The right to administer may be subject to restrictions. However, a law which takes away the right of administration altogether from a religious denomination would violate the right guaranteed by Article 26 Clause D.
Articles 27 and 28 further reflect the constitutional commitment to the principle of secularism.
Article 27 of the Constitution prohibits the collection of any tax to promote any religion. The Supreme Court in the Shirur Mutt case stated that Article 27 expresses the policy that the state should not promote any particular religion out of public funds. Article 28 is primarily concerned with the question of religious instruction in educational institutions. It differentiates amongst three types of educational institutions. In educational institutions that are wholly maintained by state funds, there is a complete bar on religious instruction.
There is an absolute prohibition based on the principle of secularism, as state money cannot and ought not be associated with a particular religion.
Such instruction is permissible in institutions where the state merely administers an institution that has been set up for a religious purpose. Where the institution in question is an aided institution and religious instruction is being provided, taking part or attending such lessons is based on consent. No one can be forced to attend such classes. It is important to understand that only religious instruction is prohibited. Academic study of religion or any other belief is not prohibited.
Thus, the Indian Constitution, being a secular constitution, protects the right of people to their religious beliefs and to propagate their religion. In addition, the rights of religious denominations have also been separately identified and protected. These provisions seek to ensure that the state does not discriminate against any religion or belief system. That broadly is the scheme of freedom of religion as enshrined in Articles 25 to 28 in Part 3 of the Constitution of India. Thank you for watching.